Thank you so much, Fatima. I just caught the tail end of that, but it sounded like a great panel. Yeah, like she said, we are now ready for our keynote. I don't want to spend any more time not listening to Professor Vatuk speak, so I guess we'll just begin since she's here. So I'm very pleased to announce our third keynote speaker and introduce her, Professor Sylvia Vatuk, Professor Emerita of Anthropology at the University of Illinois in Chicago, who's going to be speaking on Islamic feminism in India, Muslim women activists, and the reform of Muslim personal law. Professor Vatuk is Professor Emerita of Anthropology at the University of Illinois, Chicago, with a BA in Sociology and Anthropology from Cornell University, an MA in Cultural Anthropology from the School of Oriental and African Studies, University of London, and a PhD in Anthropology from Harvard University. Her doctoral research in Meerut, UP, led to the publication of Kinship and Urbanization, White-Collar Migrants in North India, published by the University of California Press in 1972. She has subsequently carried out ethnographic research in Delhi, Hyderabad, and Chennai on both Hindu and Muslim marriage, family, and kinship organization, with a special emphasis on gender roles and intergenerational relationships, publishing her findings in academic journals and edited volumes. Most recently, she has focused on legal anthropological questions related to India's Muslim personal law as administered in family courts, in the regular civil and criminal courts, and by Islamic clerical functionaries. Her most recent publication, a collection of previously published articles on Muslim women and the law, is Marriage and Its Discontents, Women, Islam, and the Law in India, published by Women Unlimited in 2017. Thank you so much for joining us, Professor Vatuk, and for agreeing to be our keynote. Without further ado, please, when you're ready, and I'll be sharing the slide for you. Just let me know if everything is okay.
You need to mute yourself, Professor Vatuk. Unmute yourself, sorry.
Sorry about that. Okay. What I wanted to know is about the slides. Should I tell you, Sheelalipi, when I want the next one?
Is it just the one slide?
No, there were three. Oh dear.
Oh, I just received the one.
Oh, okay. Well, that's fine. It's not important.
Oh.
Thank you very much for organizing this panel. It's been extremely interesting, and I wish I'd had a chance to listen to more of the presentations. But in any case, thank you for inviting me, and I will launch into my presentation now. In recent decades, growing numbers of Muslim women in India have been publicly calling for the reform of Muslim personal law, justifying their demands for gender equity with religious arguments, referring to the authority of the Quran rather than to the Indian Constitution or to the universalistic principles of human rights that have so long guided Indian secular feminists in their campaigns for a gender-neutral, uniform civil code of personal law. These women's perspectives on the question of gender and equity in Islam follows a trend that has been seen in recent decades all over the Muslim world, in which what Yogenda Sikand has called, quote, a new breed of Muslim women scholar activists that are seriously and critically studying the foundational texts of their religion, challenging conventional histories and canonical texts, pointing to the openness of the Quran and Sunnah to ijtihad, looking at the context in which the Quran was revealed and applying this understanding to the present. In the process, raising serious questions about the ways in which Islamic knowledge has been produced over the centuries in the Muslim world more generally and in India specifically. Scholars of the Middle East began in the 1990s to use the term Islamic feminism for such movements, which were then gaining prominence in Egypt, Iran, and elsewhere. Women were attempting there, through a rereading of the Quran and early Islamic history, to reclaim their religion and undermine both Islamist patriarchal distortions and Western stereotypes of Islam as backward and terroristic. In their view, the Quran is not the misogynist text that it is so widely believed to be. Their goals were to achieve greater gender equity under the laws of their respective countries and in their societies more generally, not by rejecting Islam, but by trying to reform it from within, showing Muslim women, and hoping to eventually convince their menfolk as well, that patriarchally minded male religious leaders had for centuries been foisting upon an illiterate public their own misleading and self-serving interpretations of God's teaching and of the prophet's life, interpretations that have led to an unjustified devaluation of the female sex and a denial of women's God-given rights. While the goals of these women activists are similar to those long pursued by secular feminists, their understanding of the sources of male bias in Muslim societies and many of the remedies they propose to combat them are quite different from those of women in the former group. I should say right now that the term Islamic feminism is not one that these activists would use or do use for themselves. In fact, they largely disavow it, mainly because the image of feminism that others in their communities hold, and that in many cases they themselves hold as well, is a highly negative one. Their reluctance to openly claim a feminist identity, at least when campaigning for women's rights before a Muslim audience, is understandable, since the term, not only within the Muslim community, but in India more generally, except perhaps among the English-educated upper and middle-class elite, has a distinctly negative quality. It provides images of an excessively westernized woman, unfeminine, aggressive, antagonistic toward men, immodest, sexually loose, and careless of domestic and family responsibility. This is obviously an image with which they do not wish to be associated. However, scholars continue to find the phrase a convenient label, and I, like others who have written about their activities in the academic literature, have chosen, despite my reservations, to use it here as well. Islamic feminism in India is not yet an organized movement in the strict sense of the term. It's being pursued by a rather amorphous assortment of individuals and groups, all engaged in avid discussion and debate about the negative impact of Muslim personal law on women, but only loosely organized in terms of action. They share similar goals: to spread awareness of the, quote, correct teachings of Islam about women's rights, and find ways to help women gain practical access to them. And they employ similar arguments to justify their calls for legal reform. Most work quite independently or in small groups, but they're well aware of one another, and even while living in distant places, find or create periodic opportunities to meet and exchange ideas. How many women are actually involved in this movement is impossible to gauge. There are a few prominent activists in each of the major cities and in certain other second-tier urban centers like Lucknow, Ahmedabad, and Calicut. Some run small to medium-sized NGOs with associated staff and have a significant local grassroots following. But even if one includes the latter in the reckoning, they are far fewer than the numbers associated with the, quote, women's wings of Islamist reform organizations like the Tablighi Jamaat or the Jamaat-e-Islami Hind. None of the current women's rights activists are asking that Muslim personal law be abolished or secularized, nor do most of them favor passage of a uniform civil code. By and large, they identify themselves as devout Muslims, and many affirm their willingness to be governed entirely by Muslim law in the realm of family relations. But even those resist being told by the All India Muslim Personal Law Board or by any other male clerical organization what that law consists of. They insist that Muslim personal law is not a true reflection of the intention of the Quran. They consider that sacred text to be supportive of the principle of gender equity, but claim that over the centuries it has been subject to highly patriarchal readings that has led to women being deprived of many of their God-given rights. As one activist explained to me, according to most people's understanding of Islam, all of the rights belong to men and all of the duties to women. And another said, there are so many rights given to women in the Quran that are not found in the books of any other religion. But the religious authorities mislead people. They misuse their position. They are an almost entirely male group. They give everything a patriarchal interpretation just to suit their own interests. So these women are asserting their right to read the Quran for themselves and interpret it in a woman-friendly way. They point to God's command that all believers read and study the holy book for themselves, using their own reasoning abilities to understand it, rather than relying on intermediaries. So they insist on going back to the foundational text for guidance, reclaiming the right to ijtihad that the Sunni establishment maintains was foreclosed many centuries ago. They also reject the notion that Muslim personal law is divinely given and therefore inalterable. They point out that it was created during the colonial period. Though based on Islamic law, or Sharia, has been modified by judicial precedent and by legislative enactments that ironically, in each case, were initiated by representatives of the ulama. So why, they ask, cannot further changes now be introduced to benefit women? Are women's, notwithstanding their insistence on the need for legal reform, they are also always at pains to emphasize that neither their religion nor their personal law are ultimately responsible for Indian Muslim women's oppressed conditions. Our women's problems are largely economic, caused by poverty, lack of education, lack of job opportunities. It's the media and the general public that always blames their problems on religion. Muslim-led women's NGOs began to make an appearance in the late 1980s. And here in this slide, you will see a list of some of the more prominent ones. The first was in 87. I'll talk about this one, Awaz in Niswan. And the next one in 99. Steps in Tamil Nadu also started sometime in the late 80s. Bazmi Shema is Niswan, I'm not sure what date, but many decades ago. And the last two are more recent, and I'll be discussing those as well. So in these various NGOs, while Muslims predominate among their staff and clientele, they welcome, just as do other non-Muslim NGOs, they welcome women of all religions, considering it antithetical to their purpose of promoting gender equality to make sectarian distinctions among themselves or among those they serve. For some, the fact that they came into being in times of heightened communal unrest reinforces their commitment to communal harmony. One of the oldest, largest, and most well-established Muslim-led women's NGOs is the Mumbai-based Awaaz-e Niswan, which means, as you probably know, women's voice. It was founded in 1987. Among its initial activities, and still continuing these, it offers literacy classes, teaches work skills to poor women, giving them the tools to support themselves financially and to deal self-confidently and effectively with the larger world around them. It provides once-a-week marital counseling sessions run by peer counselors who in some cases initially came to Awaaz-e Niswan seeking assistance with their own problems and then stayed on to use what they had learned to help others. In March of 2005, the formation of an All India Muslim Women's Personal Law Board drew national and even some international media attention. The name was modeled upon the name of the major Muslim clerical organization called the All India Muslim Personal Law Board. So they put women into that. It was conceived by a small group of prominent women who had gathered in Lucknow for a wedding. They cited as the motive for doing this the failure of the mainly male All India Muslim Personal Law Board to seriously come to grips with women's concerns. As one of them said, despite prattling about working for the rights of women, the men-dominated boards took no account of the voice of women. 35 women got together representing the major sects and schools of Islamic jurisprudence and also including a few Hindus. They got off to a good start toward the end of February 2005, convening a women's court or Mahila Adalat, at which 166 cases of unilateral divorce and atrocities related to dowry are said to have been registered. The alleged offenders were summoned to appear 2 months later to answer the charges. However, I have not been able to find out any more information about, what happened after that. This organization was greeted by condemnation and derision from members of the All India Muslim Personal Law Board. They denied its legitimacy and questioned the women's scholarly credentials and their political connections. But it had already, that board was already becoming increasingly sensitive to charges from both within and outside of the Muslim community of failing to address women's problems. So it had already begun to pay more attention to such issues at its annual meetings, and in 2001 had organized a national conference to which it invited some of its more prominent female critics. In 2000, it enlarged the board and increased the number of slots reserved for lady members. However, at that time, there were 151 members, of whom about 10 were women. But by 2017, which is the most recent set of figures that I've been able to find, they have 251 members, of whom 40 are female. And a couple of them have even been made members of the executive committee. But the problem is that even if they voted as a bloc, they could obviously not seriously influence the outcome of the board's deliberations. The question also is, how are these women selected? No doubt for their views. Some observers complain that in any case, the women who are on the board do very little to promote women's causes, either because they genuinely share the conservative outlook of the male majority, or because, as one woman told me, they are simply too scared to speak out against the board's patently patriarchal biases. They fear that if they do so, they might be accused of dividing the community or of challenging the authority of the mullahs. In 2007, a new organization dedicated to voicing the concerns of Indian Muslim women was inaugurated at a meeting in New Delhi, attended by more than 350 Muslim women from all over India, along with many academics, social activists, and government officials, many of them non-Muslim. This is the last one that I've mentioned here, Bharatiya Muslim Mahila Andolan, which means Indian Muslim women's movement. At that time, the organization claimed to have already enrolled 5,000 members from throughout the country. Its membership had reportedly grown to 23,000 by 2011, 42,000 in 2013, and according to a recent news report, now numbers over 70,000 members. As these numbers suggest, an acronym is the BMMA. It has a very different organizational structure from that of some of the other earlier Indian Muslim women's rights networks, which I haven't had time to talk about. Rather than being a coalition of like-minded NGOs, the BMMA is a mass organization enrolling individuals rather than groups as members. Like most other Muslim-led NGOs, it welcomes non-Muslims to join its organization. And in 2011, non-Muslims made up about 10% of the total. It also enrolls some men, but it has a specific policy of reserving leadership roles and 20% of its membership to Muslim women. This is based on the belief that the mainstream women's movement in India has historically been so dominated by upper class Hindu women that the concerns of Muslim women have never been given the attention that they deserve. The BMMA has branches in 15 states, all guided by its core values of democracy, secularism, equality, nonviolence, human rights, and justice as enshrined in the Constitution of India. This is what they say in their website. Each branch initiates and carries out its own projects to ameliorate the overall conditions of the local Muslim community, and particularly its women, while also helping the latter to raise their voice at the national level. The main focus of these projects are those that they have identified as particularly critical for the Muslim community, namely education, livelihood, health, social security, and law reform. Legal reform is thus only one of several items on their agenda, but appears to be the one that the national headquarters is most directly and actively involved in, at least the one that gets the most publicity. In line with its commitment to equality and democratic decision-making, they hold state consultations to discuss the issues before taking a long-term project of designing and working for the codification of a more woman-friendly set of family laws for Indian Muslims, whose law is currently very little codified. At these meetings, participants were encouraged to identify those aspects of the code that affect them most negatively, to prioritize their concerns and suggest specific reform measures. Until recently, their main concrete accomplishment in this area was to draw up a model marriage contract that a few years afterwards was issued a few years afterwards in 2008, and was said to have been used by 40 marrying couples in Mumbai and 200 group marriages in the one district of Gujarat. Since then, BMMA has not only grown in terms of membership, but has actively pursued its agenda in other ways. Among its more recent noteworthy accomplishments are the establishment in 2013 of 4 women's Sharia courts in Pune, Ahmedabad, Mumbai, and Dindigul in Tamil Nadu. These courts are presided over by women who have been trained by the organization as female qazis, or Muslim judges. They are taught about Islamic law, specifically as it pertains to marriage, divorce, child custody, inheritance, and the like, and are also taught about the structure and mode of operation of the state judicial system and of its role in administering Muslim personal law in particular. They also help poor women who've been abandoned or divorced navigate both systems, helping them to obtain maintenance award from their husbands, negotiating with husbands for khula divorce, that is a divorce that is initiated by the wife, or when that fails, helping them to file for a state divorce under the 1939 Dissolution of Muslim Marriages Act. They also negotiate with the help of a sympathetic male qazi financial settlements or settlements about child support and custody with an ex-husband, or broker agreements between the pair to resume married life again under conditions that both of them will vow to adhere to in the future. In 2014, it released a draft Muslim Marriage and Divorce Act, which was, they say, based on the values and principles of the Quran, with provisions favoring women's interests to replace provisions in the uncodified Muslim personal law that they feel biased toward men. In addition, it has conducted and published the findings of a national survey of 4,700 mostly poor Muslim women in 10 states concerning their current personal situations and their views concerning the desirability of reforming Muslim personal law. More recently, it played an instrumental role in supporting and likely helping to draft the writ petition submitted to the Supreme Court asking that triple talaq be declared unconstitutional. This was the so-called Shaira Banu case. I don't think I need to go over that. I think people are are quite aware. And this was something that of course, the BMMA was very happy that the bench was a five-person bench, I believe, and 3 of whom agreed that it was unconstitutional, but left it to the legislature to do something about it. And what they did was to pass what Parliament did was to pass a law making it a crime to divorce a woman instantly like that in that triple. It did not, of course, say anything about unilateral divorces itself, because those are clearly not, those are clearly allowed by the Quran. But this issue has been from the start close to the top of most activist lists of priorities. The women do not usually speak out against this divorce per se, but they do insist that if a man wishes to divorce his wife, he should be required to do so in a so-called phased manner, pronouncing one talaq, then waiting for a month before uttering a second, during which the couple should try to reconcile their differences with help from their respective families. Only if after a second month has passed, their problems are shown to be irresolvable, should the man be permitted to utter the third irrevocable talaq. Indeed, when pressed on the point, most clerics also expressed disapproval of the triple talaq, and the All India Muslim Personal Board has even gone on record. However, all they do is to recommend the more gradual procedure that I just described. They say they cannot either ban or invalidate divorces that are effected in this matter, but can only endeavor to make the faithful aware that to pronounce a triple talaq is morally undesirable. Another issue that has gotten attention from women activists is that of khula, the woman-initiated extrajudicial divorce. This kind of divorce, in fact, is the way that most women who are seeking divorce get it. Relatively very few women go to the state courts to get a divorce, even though there is a law there that allows them to do that if they have cause, if they can prove cause. Most activists would like to make this kind of divorce more readily available. But a court divorce is expensive and time-consuming, and a woman who resorts to it risks social disapproval. On the other hand, an extrajudicial khula divorce is simply arranged and inexpensive. However, it requires the husband's consent. Activists want religious functionaries to respond more sympathetically to those women who are applying for khula, even if their husbands refuse to cooperate or cannot be located. Alternatively, they want the qazis or whatever religious authorities are dealing with it to use their option to divorce the couple for good reason themselves by the procedure called fasq in Nikah. But male clerics say they do not favor making it easier for women to initiate divorce. They reason that to do so would cause an unacceptable rise in the divorce rate. As the secretary of the All India Muslim Personal Law Board told me a number of years ago, we are in the business of preserving Muslim families, not contributing to their breakup. He explained that women are too emotional to be given the privilege of divorcing on demand. If allowed to do so, they would begin divorcing their husbands on the slightest of pretext. The result would be social chaos. Another issue that has concerned these women is that of the meher. Islam obliges a man to give his bride a dower, meher, in cash or other valuables when they marry. The amount must be recorded in every marriage contract, but need not be paid immediately. In India, its payment is usually written in the contract as deferred indefinitely. Upon pronouncing an irrevocable talaq, however, the man is supposed to hand over the full amount to the wife he is divorcing. In theory, this provides a woman with some insurance against a hasty divorce. And should her husband divorce her anyway, it can serve as a nest egg with which she could start a new life. But as there is no legal mechanism to enforce its payment, in practice, very few women actually receive it. Meher amounts are in any case often quite minimal. Activists propose that the cleric presiding over the marriage, the Nikah Kwan, insists that the groom pledge more than a token amount and either pay it in full or fix it in terms of some material asset like gold or real estate, something whose value will rise with inflation. They also want clerics to speak out against the very common practices, one whereby the husband persuades his new bride on the wedding night to waive her claim to the meher, or one in which the in-laws convince a recent widow that if she claims her legal right to be paid her meher before his estate is distributed among the heirs, he will suffer greatly in the afterlife. Polygamy, putting restrictions on polygamy are also high on these women's agendas. They contend that the Quranic injunction to treat multiple wives equally is clearly impossible, either to comply with or to enforce, and therefore a man should be allowed to marry another wife only under very special circumstances, such as the inability of the first to bear children. Then he should be required to get his current wife's permission, and the Nikah Khan should be required to ascertain that he has done so before he proceeds with the wedding. Again, neither the All India Muslim Personal Law Board or any other clerical bodies have shown any inclination to discourage multiple marriages by instituting such procedures. Now the question comes of the marriage contract. In the 90s, these activists began trying to make Muslims aware that the law permits a woman to specify in her marriage contract the conditions under which she is giving her assent to the match. For example, she can say that she can give the condition that she will be allowed to continue her education, or that her husband will not take another wife during her lifetime. She may even require him to agree that should he fail to fulfill the conditions she has set, she may dissolve the marriage herself by a procedure called talaq-e-tafwiz, or delegated divorce. In 1994, a Mumbai group that included several lawyers, academics, and NGO leaders presented a version of a contract to the All India Muslim Personal Law Board for its consideration. It included a declaration by the bridegroom as to his current marital status. If married, he was asked to affirm on the form that his first wife was aware of the second marriage, that he had set up a separate household for her, and that he had made provisions for her maintenance. Not surprisingly, the All India Muslim Personal Law Board did not embrace this document. It did take note, however, of the issue, and after years of discussion and debate, issued its own model marriage contract in April of 2005. While some activists welcomed this as a step in the right direction, most were extremely critical. For example, whether Nikah Khan is instructed to establish whether the couple is eligible to marry in terms of prohibited degrees of kinship relationship and verifying the woman's marital status. Nowhere is he instructed to verify that they are old enough under Indian law to do so. And nowhere is it mentioned that the bride may specify the conditions under which she is marrying, nor is space provided on the form for her to write them down. In March 2008, the All India Muslim Women's Personal Law Board new 4-page model Nikahnama, published in both Hindi and Urdu, was released in Lucknow at a special meeting of the organization. In addition to making it more difficult for a man to divorce his wife unilaterally by triple talaq, or by modern means of communication such as instant messaging, email, telephone, or video conferencing, or Zoom, presumably, this marriage contract requires him to pay his divorced wife's meher and make other provisions, financial provisions for her and their children. It also affirms her right to seek an extrajudicial divorce by khula under certain conditions. So how am I doing in terms of time?
It's fine. You're fine. If you could just maybe conclude, then we'd have some time.
Yes, I've just got to the conclusion. That's good.
Amazing.
So many scholars and others have questioned this Islamic approach to gender justice, which these women are promoting, questioning whether it is in any way a viable way of getting, of getting more gender equity in the law. They feel that some critics insist that insofar as they choose to confine themselves to changing Muslim personal law from within and rely on the Quran for guidance and side with the ulama in their rejection of state intervention, as some do, although not all do, they risk having to scale back their aspirations for true gender equity under Indian law. A slightly different but related fear is that, in Janaki Naya's words, it may be too early for feminists to take heart from the growth of Islamic feminism in India, because blatant changes to the authority of the ulama may have the unfortunate consequence of providing them a rallying point for a new patriarchal unity and lead to renewed attempts on their part to make women give priority to community solidarity over pursuit of their interests as women. I'm somewhat more optimistic than Naya on this point. It seems unlikely to me that the women whose activities I have described here will allow themselves to be distracted by religious identity-based appeals of this kind, that Naya is hypothesizing. This is especially true for those among them who are already more or less openly calling for taking the next step, that is, working to get women their Islamic rights, but preparing them to go beyond Sharia to obtain those that the Quran does not provide. And the BMMA certainly falls into this category. There is little sign that I can see that these women can be made to stop and reverse direction anytime soon. It is also clear that, realistically speaking, there is, for a variety of political reasons, little or no prospect that a uniform civil code or even any effective new legislation within Muslim personal law will be enacted in India in the foreseeable future. 3 years ago, in response to the Supreme Court judgment in the Shayara Banu case, in which a majority of justices agreed with the plaintiffs that the so-called triple talaq is unconstitutional, Parliament enacted that law, making it a criminal offense to divorce one's wife in this particular manner. Its passage has been hailed as a great victory by Muslim women activists, the BMMA, and others. However, that law does nothing to alter the fact that a Muslim man can still unilaterally divorce his wife without providing any reason or providing any official authority or getting permission from any authority for what he wants to do or has done. The only difference now is in the timing of the pronouncements, whether they are all three made on one occasion or they are made over a period of 3 months. This criticism, of course, is aside from the many other questions about the law. For example, how is this actually going to work, and whether putting the offending husband in jail is going to be truly advantageous for the wife who is left behind and now has no means of support whatsoever. Under these circumstances, an Islamic feminist approach seems to me to hold considerable promise, at least in the short run, for improving the legal lot of Muslim women. The movement may at least make some concrete progress toward remedying the consistent failure of the religious authorities to implement those provisions of Islamic law that activists believe were originally designed to protect women and their well-being, and which are admittedly so by the clerical establishment, but are widely ignored in practice today. More importantly, as their voices become more and more persistent and make the Muslim community, clerical and lay alike, increasingly aware of the issues and of the remedies they propose, it seems to me that some amount of change is inevitable. Clearly, an approach that merely seeks to obtain for women those rights provided to them in the Quran will not lead to complete equality of the sexes, but it is nevertheless a promising beginning and is headed in the right direction. Thank you. Any questions?
Thank you so much, Professor Vatuk. That was a thorough history, not only of the history of the Muslim personal law, but also the many important interventions that women's organizations have been making in reforming the law and opposing what is necessary, while also building on the importance of the law itself. And thank you for juxtaposing the Muslim personal law as well as, the Uniform Civil Code, and sort of what has been happening with respect to, the progressives and the so-called fundamentalists, and why they follow and support and in what regard. Thank you so much. I have a question of my own that I'd like to ask, but any of you still watching, please, if you have a question, leave it in the chat, or you can always raise your hand and I can call on you after. So I have a question about the Shah Bano case, which is, I know, a very important, significant case, I think, but definitely not the only one where a Muslim woman sort of spoke out. And but that is one of those cases that was instrumental in a lot of ways in understanding the complexity of the Muslim personal law. And having read, papers by Zakia Pathak and Rajeshwari Sundarajan on Shah Bano, where they detail the complexity, the agency, the complexity of agency of, Shah Bano's actions in not only the way that the Supreme Court handled the decision, but also her response to it. So I'd just like to hear a little bit more about what Islamic feminism means and how that can be approached through the case of Shah Bano.
Well, of course, this case and the law that was passed after it became a cause célèbre, had already occurred by the time most of these activist women's organizations, well, some of them were already there, but they weren't focusing so much on the legal issues. So there are also questions about that in terms of what impact it has had. After the law was passed, a case, very soon after, a case was again submitted to a suit was filed, or a writ petition, I believe, to the Supreme Court. And this was in the Daniel Latifi case, which came up with the response that it was actually still possible for Muslim women to get, maintenance through this other route, through the route of the new law, which said it had to come, the money for the maintenance of, or the maintenance order had to be not against the husband, but against the natal kin of the woman. And so then there was a question of how successful this was going to be, because, first of all, women are not going to want to, file a suit against their own parents if they didn't do it, and so on like that. I did some research. This is a small project in the magistrates' court in Hyderabad on this question to see what was actually happening. And what I found was that indeed many women had begun once it became more widely known that this was an option, larger, increasing numbers of women started applying for maintenance, and they were getting often very generous awards from, from their, but not necessarily from their parents. In many of those cases, it was being given because the thing says from the parent, from the natal family, or if the natal family relatives or the children don't, or their adult children don't have the ability to pay, then it should be paid by the Waqf board of the state. So increasingly, these awards are being given against the Waqf boards, and more Waqf boards in different states started, setting aside money for this very purpose. So it gets very complicated, and also another thing that I found was that most of the awards went to women whose families had quite a lot of money. Poor women who would have been the ones who previously could apply under Section 125 of the Criminal Procedure Code. There's no point in the court ordering them to pay a certain amount of money if they don't have it. And so they were, kind of getting left behind. It was more advantageous for well-to-do families, women from well-to-do families, than for those things. So now that the Waqf board is paying it, it's beginning to help. But, the numbers are still small. But this is not an issue that I have seen any of these Muslim women groups talking about. They talk about many other things. In fact, one of the other slides I had, which somehow didn't get through, was a list of about 12 different issues. One of them is the issue of halala, where if a couple divorces, they cannot get together again unless the wife has consummated a marriage with another man, divorced, and so on like that. They also are concerned with child custody and child guardianship issues, and others. I won't go on and on, but this is not one that has ever come up in any of my conversations or in their literature, their statements or anything. So I don't know if that answers your question, but.
Yeah, no, that absolutely. Thank you. We have another question from Zara. Zara, if you'd like to ask.
Thank you so much, Professor Vatuk, for that illuminating talk. It's been, it's really been such an honor and a privilege to hear you speak and have you grace us for this keynote. But my question was with your closing point, basically about the triple talaq verdict and the responses amongst Muslim women and particularly activist circles about that. So I was wondering if you could possibly contextualize this in the current politics of the Modi government, from which is the context in which this law emerges. So I was wondering. If you think that the Hindu nationalism at play here, how does it affect the Muslim women activist response to the law, and your own analysis of the situation? Thank you.
Let me be sure what you're asking. You're asking how does the present political situation affect their response? Is that what?
Yes. How does it affect the Muslim women activist groups' response to the law?
Well, of course, they were already very enthusiastic about the law, and the BMMA took a very active role. It isn't clear, but there are reasons to suspect that the BMMA was also active in getting these women together. And this is not anything that I can prove, but it seems to be the case that at the very least, the BMMA people and Shai Rabano and the others who participated in that and wrote up that writ petition were definitely in contact before. So this was something that was has been very high on their agenda. And naturally, when the judgment came out, they were thrilled. They seem also to be very much in favor of the law. But on the other hand, I mean, it certainly, the fact that this law was passed reflects that whole, the current government's attitude toward Muslims, negative attitude toward Muslims. So but it's a situation in which these women are happy that something has been done, that there's now going to be some enforcement of the right of women to get divorced in a gradual manner, rather than just the guy gets mad and says, I divorce you 3 times. But so it seems to me there's a puzzle there. I know that, well, for example, Flavia Agnes, who is an activist. I mean, she's not a member of this particular group, but she's certainly an activist in terms of women's rights and Muslim women and other women. And she has been very critical of the law, and others have written criticisms. I have written also criticisms of many of the provisions of the law. And clearly, they reflect a way, well, we're going to show these Muslims, that you get that effect. And when you look at who voted for it, it's pretty clear. So I don't know, it's one of these ambiguous things.
Absolutely. Thank you so much, Professor Vatuk. That's definitely a really important question there of that context. So thanks a lot for that important answer that really put it into context for us.
Thank you. And we just have one more question that we'll take from the audience. It's from Aisha Bhindiwala. She says, thank you for the insights into Muslim personal law. I have a practical question based on your research experience. How can a woman getting married in India proceed with preparing or signing her Nikah contract to protect herself from unforeseeable events?
Well, this is definitely a problem. First of all, how many women who are getting married in India, Muslim women, ever even see the contract? The contract is negotiated between her male elders, her father or grandfather, whatever, and the male elders of the husband-to-be. Probably the groom doesn't even see it in many cases, but certainly the bride doesn't. The guys sign, the women and men are in a separate room or in a separate building even. The guys sit around and they sign the contract, and then they bring it over to the woman and say, do you agree to marry this guy? Now, she probably doesn't even read it. I mean, probably a good percentage are illiterate in the first place, but even if they can read it, there's no time. And they look at her and she doesn't dare to say anything, even if she really doesn't even want to marry him, never mind what's in the contract. So, it's a question that just a highly educated, English language speaking woman who has some, whose family recognizes her independence will perhaps show it to her. There's a standard form in most places, and the standard form it's like a checklist, and there's no space on there for what are your conditions. So where are you going to put it? And how is the woman going to insist. I mean, she has to argue with her father, really, first of all. So until fathers begin to think, oh, it's better for my daughter if she can put some things in here that will be, some conditions. But I mean, from a practical point of view, it's something that maybe a few individuals can do, but how this could become a general thing unless those who make up the forms, which is basically the male clerical establishment, unless they start making forms that give this possibility. And then you've got to educate. How do women know that they're even able to put in? How do the fathers even know that they're able? I don't know. I think it's just not going to happen anytime soon.
Thank you so much, Professor Vatuk. That was truly such an important talk. And as for the Q&A, I mean, I think you shared a lot of light, which was necessary on, like I said, women's organizations and the interventions that women have been making, and how the importance of listening to these women and what they want, as opposed to the impositions on something that primarily concerns women's rights. Thank you so much.
Could I just say one more thing? And that is that I think it's really important in looking at all of these things is not to be looking at it as something way up here, but to look at it in the context of the actual society, the actual culture, the actual situations in which women are living, rather than thinking of it more in a theoretical, well, let's put this in the law, but how does it really affect your everyday person?
Absolutely, yes. Thank you. That concludes our day 2 of the symposium. We'll see you again tomorrow for our final day, where there are more fascinating presentations and our keynote from Professor